The Patent Office has been trying to become more relevant in correcting the mistakes that they made when they allowed certain patents in the first place. Over the last several administrations, different directors of the PTO, lobbying Congress, have tried to put in place laws that would allow people to challenge patents in a more cost-effective way and in a shorter period of time than going to litigation. So this is about a new proceeding at the Patent Office called post-grant review. The cost of a post-grant review is likely to be a fraction of challenging a patent in a district court case. There's really two parts of this post-grant review proceeding. There's a briefing, a written part of it, and then there's a hearing in front of a panel of administrative law judges. Part of the theory of these post-grant reviews is that it should be easier to do this administratively than in the district court. You should be able to do it cheaper, more efficiently, and because the Patent Office in part is trying to protect the public from the patent monopoly, that's why, in part, they have a different standard of claim construction and they have a lower burden of proof. At the district court level, the standard is clear and convincing evidence, far greater than the standard that's used at the Patent Office, which is just a preponderance of the evidence. In other words, more likely than not that the patent is invalid. If you get a letter from a non-practicing entity, which is the polite term that we use in our business for the patent troll, you have no leverage. It's like a holdup. They come to you and they say, you're infringing our patent, we're a non-practicing entity, and your reaction to that is they're going to sue us. And so you're in a situation where you either have to pay them off or you're going to face a costly litigation. It's going to be expensive. It's going to be disruptive to your business. The post-grant review gives you the opportunity to gain some leverage in that situation, in that you can say to the patent troll, look, I'm not going to pay you an exorbitant amount of money just to avoid this lawsuit. What I'm going to do is I'm going to file this post-grant review proceeding against your patent, and then if you try to sue me, I'm going to go in and get that lawsuit stayed. In the meanwhile, you're just going to be spending a lot of money fighting me in the Patent Office. I believe there's a high probability I'm going to defeat you, and your attempt to go harass other people with this patent is going to be severely hampered because they're all going to know that you and I are fighting in the Patent Office rather than fighting in a district court. So the answer to the question is that it potentially gives you leverage in that scenario that you would not have had previously.